The government, even under interim conditions, has managed to halt the decline and revive the country's economy. The most important success in 2010 is the redimensioning of relations with the European Union. In January 2010, the process of negotiations on the new association agreement started, and in March a strategic document, Rethink Moldova, was adopted, which sets the development priorities of the Republic of Moldova for 2011 to 2013, priorities to have solid financial support from the EU. At the meetings of the RE-EU Cooperation Council, the dialogue on the creation of a free trade area between Moldova and the EU and the liberalization of the visa regime were officially launched. Finally, special relations with the EU have opened new perspectives for Transnistrian settlement. The governance of the Alliance for European Integration, AEI, has begun a series of reforms in line with the 2009 to 2013 governance program, European Integration, Freedom, Democracy, Welfare. But the provisional government and the politicization of the public administration marked the concern of the AEI components for their own electoral interests, to the detriment of a consolidated government. As a result, a number of reforms announced in the governance program were suspended until the political stability after the early parliamentary elections was established. The most conclusive example in this respect is the field of justice, where a number of reforms have begun, with laws on law reform, liberalization of the enforcement system, etc. However, the shortcomings set out in the Parliament's declaration on the state of justice in the Republic of Moldova have not been removed at all. 2011 will probably be a very difficult year for Moldova. If in 2010 the AEI had passed the resistance test against the PCRM's retaliatory intention, then in 2011 it will have to pass the test of the loyalty of its own components to the commitments set forth in the AEI Reconstruction and Operation Agreement. The main challenges for the AEI will be related to addressing the issue of the election of the head of state. There is no doubt that safe procedures, in accordance with constitutional and legal provisions, can be identified regarding the finalization of the election of the head of state, leaving only the efforts of the AIE components to be coordinated. It is noteworthy that in the situation of the vicious circle that has been created with regard to the election of the head of state, there are no expressly set deadlines, which leave wide scope for maneuver to set favorable terms in order to successfully conclude the exercise. The second major challenge for AEI is the local elections in early summer. There is a risk that, in particular, the fight for Chisinau city could dramatically undermine the AEI's cohesion. That is why, in general, the introduction of political stability could only be discussed after the constitution of the majority in the district councils in July 2011. Association for Participatory Democracy. Nor was it an official website for research conducted in sources available on the Internet. Anatol Petrencu, born May 22, 1954 in Kozani, Republic of Moldova, politician and scientist of the Republic of Moldova. In 1990 to 1992 he was Dean of the Faculty of History of the State University of Moldova, and between 1998 and 2006 he was President of the Association of Historians from the Republic of Moldova. Between 2006 and 2010 he was chairperson of the European Action Movement. Since October 2010 he is the director of the Institute of Social History Pro Memoria, vice president of the Liberal Party. Wikipedia, accessed January 4, 2012. On the morning of January 29, 2009, Moldovan Prosecutors' Day, Anatol Matisaru was detained in front of the Prosecutor General's office in Chisinau, as he claimed a protest dressed in a pork suit and used an audio system to produce similar noise as a pig. He protested because he would have been inappropriately treated by prosecutors as a result of a plunger. In plus, he challenges 2 criminal investigations against him, which he considers based on evidence produced. Anatol Matisaru was detained for 5 hours and accused of not properly informing the mayor, non-observance of police orders, opposition to arrest and insulting police and prosecutors. He said he was hit by a police officer while in detention. Amnesty International, Access January 4, 2012. All of this leads to the conclusion that, objectively, the applicant's fear of persecution is unfounded, not having a real foundation. 2.C Analysis of the cumulative fulfillment of the conditions for giving the presumption of good faith. His statements were not considered plausible as to whether he was persecuted by the authorities, given that the party whose very important member is currently in power. Must also took into account the fact that the one in question chose the first time to apply for asylum in Poland, although he would have had the opportunity to come directly to Romania. Moreover, because the procedure was prolonged, he went to Germany illegally. It was only when he realized that he could not get the protection of either country, especially because he had been forbidden to enter Schengen for a period of 5 years, then chose to come to Romania and ask for protection. In addition, it should be noted that the applicant knew about the possibility of such asylum in Romania as of 30.07.2009 when he submitted the petition to Traian Băsescu at the Embassy of Romania, receiving the answer that he must be on the territory of Romania to lodge such a request. The applicant himself also explained that in 2010 he was recommended to obtain a visa to enter Romania, and yet he chose to go to Belarus, then went to Poland and Germany. In this regard, the UNHCR Handbook on Procedures and Criteria for Determining the Refugee State under the 1951 Geneva Convention and the 1967 New York Protocol, paragraph 62, p. 17, distinguishes between the notion of migrant and refugee, respectively. A migrant is a person who, for reasons other than those contained in the definition, voluntarily leaves the country with a view to establishing it elsewhere. He can move from the desire of change or adventure, for familiar reasons or for other personal reasons. Therefore, a distinction must be made between these two categories of people because, unlike immigrants, refugees do not choose to leave their country of origin, but they are forced by certain circumstances to do so. The key difference between refugees and migrants is that they enjoy the protection of the state of origin, while the refugees do not. There is no causal link between the arguments retained during the interview for which the applicant does not want to return to his home country and the purpose which led him to ask for the protection of the Romanian state. Also taking into account the fact that he failed to make clear evidence of the elements of persecution. In view of the above, we appreciate that the applicant does not apply the provisions of Article 15 of Law No. 122/2006, with subsequent amendments and completions, regarding the presumption of good faith. From the analysis of the fundamental concept of fear based on persecution, in terms of the two elements that make up it, the subjective and objective element does not result in the existence of a real basis of fear of a probability of persecution within the meaning of the legal provisions on granting the state of refugee. 2.D Conclusion. Taking into consideration the above-mentioned, Mr. Plop Andrei's request does not meet the conditions stipulated in Article 23 paragraph 1 of the Law No. 122/2006, as amended, and the subsequent completions, for granting refugee status. 3. Analysis of the asylum application from the point of view of the elements of the definition of subsidiary protection. A notable difference between the refugee state and the subsidiary protection is that the latter is granted for cases that do not qualify for the granting of refugee status and where there is a risk of life injuries, and the risk of torture, inhuman or degrading treatment on grounds other than those provided for in Article 23 of Law No. 122/2006, with subsequent modifications and completions, race, religion, nationalism, membership in a particular social group or political opinion. That is clearly apparent from the wording of Article 26, 1. 3.A Analysis of the serious risk of sentencing to death or executing such a punishment with regard to the provisions of Article 26, 2, 1, of the applicant's statements. he does not appear to be in danger of being convicted of the death penalty or the execution of such a penalty, because, although he has asked, he did not refer to it. 3.b Analysis of the serious risk of torture, inhuman or degrading treatment or punishment. The lack of credibility of the claimant's statements on general issues determines that there is no serious risk of being subjected to torture, inhuman or degrading treatment if returned to the country of origin. With regard to paragraph 2, the applicant has not provided any circumstantial evidence that there is a serious and present risk of being subjected to torture, inhuman or degrading treatment if he returns to his/her country of origin. 3.c Analyzing the serious risk of serious threats, individual, to life or integrity, as a result of generalized violence in situations of domestic or international armed conflict, if the applicant is part of the civilian population. At the same time, it is remembered that the state of Moldova is not involved in an internal or international armed conflict in order to analyze whether the applicant risks a serious, individual threat to his life of integrity when he returns to his country of origin. Internal armed conflict is defined in the literature as a form of violence within a state, which has held a certain degree of intent and a certain balance between the armed forces of the legal and rebel governments, and which presuppose the existence of an organized civil authority. 3.d Conclusion Taking into consideration the above mentioned, Mr. Plop Andrei's request does not meet the conditions stipulated in Article 26 of the Law No. 122/2006, with the subsequent amendments and completions, for the granting of the Civitas protection. The attached information on remedies is an integral part of this judgment.